reality is the legislation is pretty tough on this. And in fact, most people don't follow the regulations properly. So the gas safety regulations have two obligations within them. The first of these is that the tenant, and they're sort of backwards in the regulations, which doesn't help. So the first of the obligations is that the tenant must be given a new gas safety certificate within 28 days of it being redone. It must be redone every 12 months. So when the tenant's in the property, you must get a new gas safety every 12 months, and the tenant must be given a copy of that within 28 days. The second obligation is that the tenant must be given a copy of the gas safety certificate before they occupy the property. To repeat that, before they occupy the property. So before a tenant moves into a property, they must be given a valid gas safety certificate. Now, in practice, that frequently does not in fact happen. There's a lot of situations in the industry, both because of letting agents and the way they operate, and because of landlords doing various things wrongly, where people have gas safety certificates, but the tenant moves into the property and gets given the gas safety certificate with a pack of other stuff, often including the tenancy deposit information and the how to rent guide and all of that stuff, after they have moved in. Now, technically, that is a violation of the gas safety regulations. But in reality, of course, nothing ever happened about it. The Health and Safety Executive is the prosecuting body for gas safety regulations, and they tend towards a no harm, no foul enforcement position. So basically, if you haven't got a gas safety certificate, but no one's been hurt as a result of it, so your gas appliance is basically safe, they tend not to prosecute. That said, if someone is injured or killed, then you can expect to have the book thrown at you, and you're very likely, in fact, to end up in prison. So their enforcement is a bit more light touch, and from some people's point of view, lighter touch than it should be. It's debatable whether in fact there should be more proactive enforcement to make sure people actually have gas safety certificates. There are some statistics out there that show that in the rented sector, the private rented sector, it may be as bad as only 50% of properties having a gas safety certificate. So it may be as low as that, which is pretty poor, really, given how long these regs have been around. And of course, the incredibly negative consequences involved in poorly serviced and maintained gas appliances. Anyway, all of this kind of changed when we altered Section 21 by way of the Deregulation Act 2015, which came into force in a sort of transitioning period right through for a period of 3 years from 15 to 18. He had decided, and pretty much every other judge was following his position, that if you didn't give the tenant a gas safety certificate before they moved in, that was a one-time event. It wasn't fixable by giving the tenant the gas safety certificate later. And so you ended up in this position where you could never serve a Section 21. And for all intents and purposes, the tenancy had been converted from an assured short hold into a fully assured tenancy, where the tenant could in effect stay for life. So Section 21 had been eliminated as an option. Now, and I suppose that sort of summarizes the position quite neatly, I hope.
Yeah, thanks, David. It does, and I think what I'm taking from this is that there's a moral question, which is at the heart of this, which is from a tenant's perspective, they ought to know they must have things within the property that are safe, so they shouldn't be exposed to risk of faulty gas appliances and installations. They ought to have the information, and then on the other hand, if the regulations, and I think this is the other point, which is the poorly drafted regulations, I would argue, have the impact that was being held in the county court, then a one-time administrative error would effectively prevent a landlord from ever being able to serve a Section 21 notice and effectively remove certain rights from a landlord that they would ordinarily have. And so at the heart of it, you've got I'll describe them, two unattractive positions and some poorly drafted regulations underpinning both of them. Is that how you look at it as well, David?
Yeah, I mean, as I've already said, I'm no apologist for people who haven't got gas safety certificates. You should have one. And the trouble about this is that the penalty potentially is very draconian, because you can never serve a Section 21. For Carrow Ransfield, the landlord, Carrow House Limited, is a landlord down in Cornwall. Miss Ransfield is a tenant of that property. It's actually flats within a larger block. the gas appliances aren't in the individual flats, they're actually in the common areas, but Carroll House controls the whole thing, so they are still responsible for them and are required to have gas safety certificates. They said they had served a gas safety certificate on the tenant after she had moved in. She denied ever having received it at all, but that's a separate issue that's going to be dealt with later. There were some difficulties around one of those gas safety certificates in that it was conducted, or the inspection was conducted, but then the engineer went on holiday, basically, didn't, without producing the certificate, and he came back and then produced the certificate, but the date on the certificate was wrong and showed the date that he produced the certificate, not the date the inspection had been done. And then they did a further certificate, which may or may not have been served prior to a Section 21 being served. So there's a series of situations that are all messy there. It went to Truro County Court and was appealed in Truro County Court, and it ended up in the position, broadly speaking, that the county court, the circuit judge, so the second appeal in Truro County Court, said that he wasn't bound by the Carradon decision, but he elected to follow it. And he declined to give possession, basically, on the basis that the gas safety regulations hadn't been complied with because the tenant hadn't received a gas safety certificate before she'd moved into the property, which was an accepted point. And from there to the Court of Appeal is where we are. How can you even know that which you rented out was safe?
Yeah.
Obviously, there will be circumstances where it's not really landlord's fault. I mean, I've seen cases where, for example, there was a few years back now, there was a housing estate built by a major national house builder who I won't name because they might send me a letter threatening libel action. But basically, the entire housing estate had defective gas installations, and while they had provided installer certificates, they were all effectively wrong. And you couldn't get a gas safety certificate for the entire estate. So you've got situations like that. You've got problems with forged certificates. You've got people who are completely ignorant of their responsibilities. So I guess some of those people will still suffer, but I think you have to draw a line somewhere. And where the line is drawn. But partly, though, because the point was never arose in this case, to be fair.
And what did arise in this case was that an invalid gas safety certificate isn't a gas safety certificate. So when we're talking about the provision of a gas safety certificate, it has to be a valid one.
Yeah, that was quite interesting, actually. I mean, this wasn't meant to be part of the case. It just came up. But a gas safety record under the gas safety regulations must include the date on which the appliance or flue was checked. So a gas safety certificate must include the date on which the check was done. And what had happened here is that the gas engineer had done the check, somewhat lackadaisically buggered off on holiday, not done the certificate. He'd then come back from holiday, fed it all into his computer system, which is provided obviously by his accreditation body, which spits out a certificate. But the trouble is that those certificates it spits out, you can't change the dates on them. They're run on, the computer system basically is designed on the assumption that the engineer will do the check and do the certificate the same day. So you won't be doing it at 11:59 p.m. or something. And so it will only produce a certificate with that day on it. So the certificate basically was wrong. And in that sense, the Court of Appeal said, no, it's defective. If you have a tenant with rent arrears, the pre-action protocol requires you at the earliest possible opportunity to give the tenant a full statement of their arrears and of their rent history for at least the last 13 weeks, and to give them one every quarter, and also to try and agree with them a repayment schedule. And if they stick to that, then you can't go any further. The protocol also requires that if you issue a notice that has a mandatory ground for possession, so a Section 8 notice citing ground 8, or a Section 21 notice, that when you send that to the tenant, you give them the reasons why you are doing so. So one thing is, of course, many people do at the moment is they serve a Section 21 notice and they refuse to give reasons. The pre-action protocol will effectively require you to give reasons.